Hello, everybody, and welcome. My name is Tracy Ann Moore-Grant, and I am the founder of the Amicable Divorce Network. I am also an attorney, a mediator, an arbitrator, a guardian ad litem, and a parent coordinator. My office is Patterson, Butler in Forsyth County, Georgia. And today we are having an AD Talk, which stands for an amicable divorce discussion. And our topic today is how best to prepare for mediation. So today I'm joined by Traci Weiss, who is a family law attorney in Atlanta, Georgia. And I'm going to be talking to you today about my perspective as a mediator, what I think happens that will cause a really successful mediation when parties prepare and do certain things. But Tracy's going to start us off today for how she recommends parties prepare for a mediation in her practice. And so Tracy, introduce yourself to everybody.
Yes, thank you for having me, Tracy. So as you said, I'm Traci Weiss. I am an attorney with Warner Bates, which we're based in Cobb County, but we practice throughout Metro Atlanta and actually through all of Georgia. Exclusively in family law. I'm a partner there, and I'm also a guardian ad litem. So I focus on a lot of child custody related matters too. And I have been doing family law practice for over 20 years, and I've been with this firm for the last 16 years.
That's great. So mediation has become such a huge part of the family law process and is usually pretty successful if parties prepare properly in getting the case resolved. So I'm going to touch a little bit when I talk about how I see that as a mediator and what parties can do. But when you're working with a family law client, what sets them up for success in mediation?
Right. Well, as a family law attorney, I think our job is to help our clients not only at mediation, but in setting the right level of expectations of how mediation works, what can happen there, and what they can do to best prepare for it. So when they go in, they're not caught off guard by issues they hadn't really thought about. And they're ready to have their opportunity to be heard by somebody neutral, and also really work to figure out if there's a way for them to resolve all the issues in their case between each other without leaving it up to a stranger in a courtroom for what somebody can convince them of on a witness stand in one limited amount of time. So there's a little bit more preparation that needs to go in for families with children. Custody can be something that could take up a whole day of mediation in itself, especially if people aren't prepared going in. And any case that involves minor children, in addition to needing child support worksheets and things like that, that the lawyers will prepare, the parents will also need to work through issues in a parenting plan. And it's helpful if they understand going in the differences and what types of issues need to be addressed in the parenting plan. So what's the difference between legal custody and physical custody? In an amicable case, I think the presumption would be that any case is going to have joint legal custody. The parties are going to expect to communicate with each other on all major issues, have access to school records, have access to medical records, all of that. But they still need to figure out where are the children going to primarily live. And it's great to think that if you're here for an amicable case, of course, you're going to want joint physical custody. Well, maybe, maybe not. That really depends on your particular family. So it's really letting people do some soul searching of how does your family work? How involved is each parent really? Is one parent going to come in and say, I do everything and I'm the only one that does anything? And the other one's going to come in and say, I'm equally involved. You're going to have some conflict then on custody issues. So need to think through those. If both parents were equally involved throughout the marriage, then joint physical custody is definitely something you want to look at. And that's going to come from a standpoint of probably a schedule where the children are equally with both parents. But they still need to figure out a parenting time schedule, whether it's joint physical 50-50 schedule or something else, kind of figuring out what are each parent's work schedules like? What are the children's school and activity schedules like? Where's everybody going to live? Are you going to live close to each other, or are you going to have to drive through Atlanta traffic to get from point A to point B? How's that going to work? So thinking through those things, looking ahead of time at a sample parenting plan can be a really good help. So people understand what things they're going to need to think about and some ideas of ways that those can be resolved. And if it's by agreement, you have a lot more flexibility of how those are resolved than if it's left up to the court. And then things like, final decision-making authority over education, extracurricular activities, medical decisions, religious upbringing. How well have you gotten along over those issues before? Has one parent typically made all of those decisions, or has one had more leanings towards education and maybe one parent is a doctor? And, how are they going to allocate those final decision-making tasks in a way that helpfully limits dispute in the future? And then the parenting plan will also help figure out certain other things like transportation. Who's going to be responsible for driving? Is that going to be something that everybody shares? Mm-hmm. So those kinds of ideas, working through those, asking questions of your attorney before mediation, really, really helpful. So you have some idea of what's best for the family going in, what your deal breakers might be, what things you expect the other side to be really sensitive about. Will help you have a much better, much more successful mediation on those issues.
Mm-hmm, absolutely. I would say from the mediator perspective, I'm always, I shouldn't be shocked anymore, but I'm often shocked when people are there for the mediation. The case has perhaps been pending a while, and the parties just had no idea that a parenting plan form existed or what would need to go into it. And so if you look at a parenting plan, it looks at holidays and a schedule for the entire year. A lot of people think very short term, and they think, what is a normal week going to look like? But they have not thought about Thanksgiving, spring break, fall break. How are we going to handle summers? What holidays are we going to include or not? And when we take the time to do that in a mediation, I charge $2.50 an hour as a mediator. The attorneys usually are at a higher hourly rate than that. That's an expensive conversation, time consuming. So it's better when parties come to the mediation, even with a parenting plan proposal in hand, that we can work off of, or at least have an idea for what a whole year looks like. A lot of people don't think about all the major holidays and school breaks.
Yeah, I think especially with families with young children, sometimes they're surprised at how complicated the summer could be. Mm-hmm. That, it's not always easy to keep the same schedule throughout the school year and the summer break, because one parent might want to sign the children up for childcare and camps on certain weeks, and the other parent might want to sign them up on other weeks. And if you try breaking up those weeks, you might each be paying double for childcare, right, because a lot of them are going to want a full week of, registration. So those are the kinds of things too that people need to think through. And when they have older children, they need to start thinking through, well, are those children going to be trying to get a job, or are they going to have sports that are going to have them tied up most of the summer, that there may be only one limited window of the summer when anybody can travel? Looking at the calendars, looking at school calendars ahead of time is also really good to do ahead of time in preparing for mediation.
Definitely. As a mediator, I don't have it with me, but I carry a book if I'm in person. If not, I have it digitally, and it has all the different types of parenting plans in it. But I also make sure whatever county I'm mediating in it, I have that school schedule, because so often people haven't looked at next year's schedule and they get very panicked about what's that holiday going to look like. And if I can pull it out and say, oh, well, it actually starts on the 21st and ends on this day, and so this is exactly what it's going to look like for you, can reduce that anxiety. What else do you do to help clients prepare?
Well, so for families, whether they have children or not, the other things are really getting a good understanding of all the other issues that need to be addressed. And typically in a divorce case, most of that's going to be financial. So working through preparing a domestic relations financial affidavit, or we call it a DERFA for short, which, I typically try to suggest people to save every document as you're looking at things to prepare your financial affidavit. If you're downloading things off of a bank account, you're looking at your bank account, whatever it is, save each of those things. So if anybody has a question, you'll have all of that stuff readily available as you need it. And there's no question then of where you got the numbers from. But the financial affidavit, it's going to set out income and all types of income, whether it's what you get a paycheck for, whether there's a bonus, whether there are other benefits of employment. Those things are going to be important for determination of child support and for determination of alimony. If it's not a child support or alimony case, then those parts are maybe not as important. But otherwise, even just having after the income section is the budget, and that is your monthly budget. And when you're going into mediation, you really want to look at that from the standpoint, not so much of what had you been doing historically, but what are you doing post-separation and what are you expecting to do once the divorce is over? So you figure out how much do you really need to survive, to live, to have the lifestyle that you're used to. Is that possible? Is there enough money to support that while supporting separate households now instead of it all being in one place? So when you start looking through that budget and you break everything down of, okay, I pay this much for my car registration every year, and I pay this much for my HOA dues, and I break it down into monthly increments. And I think, okay, I really need to have at least this much per month to make ends meet. I think it helps to go into the mediation knowing, okay, as long as I can do this, I'm going to be okay. Right. And then you can focus more on what some of the optional items are. And then there's the net worth statement portion section, which breaks down all of the assets and all of the liabilities, any debts. I tend to use a form that gets into a little bit more detail than what the statute requires to try and think ahead on some of the questions that tend to come up. So is any of it something that somebody might claim as their separate property? Mm-hmm. If it's not separate property, it's considered marital. So separate property would be anything that you brought into the marriage and kept separate, or somebody inherited or was given as a gift, either before or during the marriage, but kept separate. And whoever's going to claim that has the burden of proving it. But go ahead and put it on your financial affidavit so everybody knows up front that's an issue that needs to be looked at. And then when were things purchased? If you know when the house was purchased and what the purchase price was for, that helps to kind of figure out some of the equity. If there's a separate interest, separate property claim to that property, you say, hey, I came into the marriage with a house and it had this much equity in it already. And then we bought this house for this much money and this much was put down on it. Don't I get a share of that off the top? Filling in more of that detail in the financial affidavit up front helps everybody to be on the same page with those questions and those issues early on. And then the financial affidavit is what the attorneys will use to put into a marital balance sheet, which hopefully also has been done before mediation, because it takes a lot of time and expense for at least 3 attorneys to be working through it together in a mediation.
Yeah, I would say in my experience, it's rare to have all of these documents prepared beforehand. So Tracy, your preparation is certainly like a unicorn, but probably saves people a lot of time and money. One of the things you touched on is the budget. And one thing that happens that is a huge hindrance to people settling at mediation is a lack of knowledge about a future budget. So generally speaking, somebody's going to be leaving the home. And they are often not knowledgeable about, are they going to rent? Are they going to buy? What's their new monthly budget going to be based on this new residence? And not having that information going into a mediation really is one of the biggest reasons that people don't settle, because they don't have the information they need to feel financially safe. And so that would be something, that I would, tell people watching this to make sure that you know what your future plan is. And you have a couple of options. Maybe if you guys aren't sure if you're selling the home or what's going to happen in each scenario, so that you're prepared to negotiate and reach a resolution either way. But a lot of parties haven't even looked into the cost of rent, or if something's in the school district, or what it would cost. And sometimes we spend time on Google trying to get those answers during mediation, which again is an expensive exercise for everybody that's involved that day.
I will say too, right now, while we're doing a lot of mediations through Zoom, it's a little bit easier because everybody has a computer handy. But when you're doing an in-person mediation, I think it's also helpful to bring along a computer and to be able to bring along your passwords for your accounts. And so if there's a question about something, you can get online and look it up and have that answer and be able to share that information as you're going through the process, so that you make the most of that day as possible. And then with the balance sheet, even if you don't have information, if you say, I don't know for sure what my spouse has, how many accounts they have, you can put placeholders. And it also reminds you to ask, even if at mediation, to fill in some of those blanks. So it's okay to say, I know that my spouse goes to this bank periodically. I have no idea what they have there. Well, then you go ahead and you put that bank name on the net worth statement portion of the financial affidavit. And as either you're preparing for mediation, it can be requested of the other side through discovery or through the amicable process of, here are the documents we still need so we can make the most of mediation. Or if you get to mediation and you say, we're almost there, but can you fill in these couple of blanks for me? Let me know what this is. Show me a statement from that bank that lists all the accounts that you have there. And then you can go ahead and add it into the financial affidavit or to the balance sheet while you're there. So when in doubt, I always would at least put a question mark in for anything you have, so you don't reach an agreement, walk away and say, oh no, I totally forgot. I think this person also has accounts somewhere else,
Exactly.
and a very full mattress full of cash, anything you can think of. If the more you think of it ahead of time, before that day that you're at mediation, the more relaxed you'll be while you're there, because you've done your homework, and the more ready you will be to actually enter into a full and final agreement.
Exactly. Preparedness, I think, is the main thing that I would, touch on as far as a mediator. I often see things across the board. I often see people who don't understand what mediation is. I've had people who haven't been advised that if we reach an agreement in mediation, it's binding, and they start to panic about that because they're not prepared. They thought maybe it was just a discussion and nothing would really happen that day. But their attorney hasn't told them, no, the plan is to reach an agreement, resolve your case, and to move on. Also, I have people who aren't prepared first to pay me. Happens a lot, even though we send out our own communication about that. The attorney either hasn't shared that or told them you have to pay the mediator, but also that we might be there for a while. I have people who have the expectation that mediation lasts 2 hours. And so they've only taken a couple of hours off of work or arranged for daycare. And so I'm the bearer of bad news to say, we might be here a little bit longer. Usually a mediation lasts about 5 hours, I would say, is sort of an average if we're dealing with a lot of the issues we typically are in a family law case. So I always want people to be fully advised as far as that.
If I could jump in on that,
Sure.
I have that same discussion with my clients too of, okay, mediation is scheduled for this day, but don't plan anything else that day. If we get in there and we're able to reach an agreement quickly, or we hit an impasse and you still have time to do other things that day, so be it. But the last thing you want is to be making good progress in a mediation, to really be finally narrowing the issues, getting close to an agreement, and somebody says, oops, sorry, I have to leave. And if you do have someplace you have to leave that you have to go to, perhaps you have to pick up the children by a certain time and there's just nothing else you can do. You've got to go and do that. Let everybody know at the start of the mediation. If you have a hard stop at a certain time, let everybody have that in mind all along. And at least then you might be able to focus on certain issues, narrow them, and plan to come back for another time to finish the other issues. Or there may be some other workaround that people can plan on. But if you do it at the last minute of, oh, I assumed we were going to be over at this time, so I have to leave now, bye. you've kind of wasted everybody's time and you've lost the momentum that mediation really can bring towards a resolution.
Yes, I always ask everybody at the beginning of the day, does anybody have any conflicts or reasons that they have to stop, so we know we have to work fast, or what kind of time frame that we have. It's always disappointing to show up for a very complex case and somebody's like, oh, I only have 3 hours. I have either court this afternoon or they have to get to work or something, because that really also doesn't set us up for success. You want to really have the time. Mediation is an opportunity to get creative with a resolution to your case in a way that the court won't do, and to really take time to come up with a good resolution. And they're serious decisions. It involves your children, it involves finances. So take that time. It's much better spent with a productive discussion on how it's going to be resolved, as opposed to much more time and cost being spent to prepare for litigation. Another thing that I would say that you touched on a little bit, and I think it's always a really good thing for attorneys to have done with clients beforehand, is to talk about sort of your highs and your lows for what is your best offer, but make sure that the client understands that that first offer that they make in mediation. I actually had this happen only one time. So I used to say this has never happened to me, but it did happen once. Where somebody made their best offer and the other person accepted it. So that's happened once, and I've been mediating now for about 8 years. So
I've never seen that happen.
Yeah, so it did happen once to me, but that was it. So that's rare. But otherwise, that best offer is usually not going to be accepted. But I would say have them have a very good awareness of what their bottom line is, because the day can get a little emotional. It can get stressful. And if they've maybe even written down on a piece of paper, I was willing to settle for X amount of child support, this type of parenting plan, this division of assets, it might help reframe them throughout the day to say, what, we're still above your bottom line, or this was your bottom line, they're offering it, and you were willing to accept that, to avoid litigation and all of those costs. I know that today has been stressful, but a lot of clients I see in mediation are surprised to hear, maybe some of the realities about alimony or asset and debt division, or, that they'll have to share in major holidays, or, some bad things. And then I'm the deliverer of bad news, so to speak, as a mediator to try to get it resolved. So I think we've given everybody some really good tips today to get you prepared for mediation. Mediation is a really serious process that can resolve your case, but it's also incredibly successful in resolving cases. If you're prepared for that success, you're mentally prepared that day to go in and to reach a resolution, and you have all the information that you need to do it. You will leave mediation that day with a binding agreement that resolves your issues and can keep you completely out of the court system, which means that you've taken control of your case, decisions about your family, and not given that to a judge who just doesn't have the time to get to know your family, and may give sort of a routine, result. And litigation can also be incredibly expensive and time consuming. If you have any questions for me, or for the other Traci Weiss, you got double Tracy's today. Our information is on this post, and you can reach out to either of us with your questions by email or by phone. And we are always happy here to help you. Thank you very much, Traci, for your time today. I really appreciate it.
Thanks so much for having me, Tracy.